Please rise. Justices of the Appellate Division, Supreme Court First Department. He, all persons having business with the Appellate Division, will hear, give your attendance, and you shall be heard.
That one. Got it wrong.
It's okay.
Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. I will begin with the call of the calendar. We are familiar with your cases, your briefs, the record, probably more than you wish we would be. So please ask for only what you need, not what you want. That way I don't have to do it for you. As right now we have about 5 hours of argument time requested, and I don't think anybody wants to be here 5 hours. Okay. People versus Nicholas Diaz. Good start. Submitted. Wilmington Savings versus Donaldson. Okay. Appellate. How much time? Okay. Would you like to shave a minute off for rebuttal? No? 5 and 5. Jewish Press versus NYPD is submitted. Robinson versus Milano.
Appellant, Your Honor, I'm not sure whether either of the respondents has appeared.
It does not appear so. Do you wish to submit or do you want time?
Your Honor, if neither of the respondents is here, I will submit.
Thank you so much, sir. Next case, Capstone Business Funding versus Shames.
No, Your Honor.
Okay. All right. How much time?
It's approximately 7 minutes. 7 minutes and 2 for rebuttal.
Oh, that's nice. 5 and 2 and 6. Okay. Pacone versus MTA. I'm sorry? Wonderful. Thank you. And everyone here would thank you too if they knew how many attorneys were on that case. All right. Rosa versus 47 East 34th Street.
Plaintiff appellant request 5 and 2, please, Your Honor.
Now, I understand that there are, how many cross appeals?
3 suspended, respondent appellant.
Okay, all right, so 5 and 2?
4 and 1, that's 34 years.
Okay. Okay. I'll do 4 and 1 for everyone. Okay. People versus William Mullen. 5 and 1 and 5. N47 Associates versus Gemsco Realty. 5 and 1 and 5. Matthew Johnson versus Leonie Cummings and Wade Cummings. 4 and 2 and 4. And I'm going to ask that you excuse me if I mangle this name. Rafal Nizinalowski versus Rockledge. Did I? I'm sorry, hold on. I think I skipped one. Rawlins versus Teachers Retirement System. Okay. Okay, let's do 4 and 1 and 4. Nizinalowski versus Rockledge. We have no appellant. Will you submit? Yes. Thank you. Okay. Adago versus Sy is submitted. Lewis versus Pierce Bainbridge is submitted. BCG Partners versus Avison is submitted. First case on the calendar, Wilmington Savings versus Donaldson. You may proceed.
Thank you, Your Honors. May it please the court, my name is Arsenio Rodriguez. I am counsel for the appellant. For the purposes of saving the court's time, my primary reason to be here is to apologize. As counsel had pointed out in his respondent brief, there were 2 items missing from the record that I unintentionally missed to put in. It was something that is unfortunate and is something that I want to own up to in person to the court.
Thank you.
It is important for the record. I think that those arguments be included. I would ask that the court either take judicial notice or allow appellant to include a supplemental record, as those contain opponents' arguments that were made at the lower court. So with respect to that, again, I would apologize. If the court were allowed to consider argument with respect to the rest of the matter, irrespective of the record, the one focus that I just wanted to point out and illustrate for the court is just the idea of a trial court giving an ultimatum to a party in how to proceed complicates the very idea of representation.
What are we talking about? Because when you have a court order to provide certain documents, that's not a suggestion. It's not a bring it in if you like to. It's an order.
And respectfully, I couldn't agree more.
Okay, so when you have an order that you don't like, or you think is inappropriate, unfair, whatever characterization you would like to appoint to it, you have a remedy.
I agree, Your Honor, but what I would disagree on respectfully is the fact that it wasn't complied with. Documents were supplied at the trial court level. Everything was provided to counsel. That doesn't mean...
How long did it take before everything was provided to counsel? After the second, the third order, how many orders did it take?
Your Honor, far too many.
Okay.
And respectfully, I was not involved at the trial court level, but still, in my opinion, for an office that I now run, far too many.
Counsel, I noticed in your brief you cite to the Corner Realty case
Yes,
quite
Your Honor.
often. How do you reconcile that case with the Messina case that this court, the Merrill Lynch case rather, that this court decided in 2012?
I would say the biggest issue with those two is that there was still an opportunity for our party in this instance to actually deliver and comply, and it wasn't intentional to avoid. So
I'm sorry. How many years did the court ask that you turn over the note? This is like basic 101 when it comes to mortgage foreclosure cases. So I understand, and my frustration is not to you personally, okay? I don't want there to be any confusion.
And there is none, Your Honor.
But this is unacceptable. And you don't get umpteen times bite at the apple, and then finally in the 13th hour, you produce a paper or two and you think you're in compliance. There are consequences to non-compliance. And this went on for years.
I wouldn't, respectfully, I agree. The only thing I would ask is, in the court's, when the court is contemplating the issue, to at least respect the fact that even after all of that, and it is the 13th hour, a party should still be allowed to present its side in its papers, which is why there was objection still, which is why there was responses. The documents were produced, but we still had a legal right to present those arguments to the court at the time. I respect everything else with respect to timing. I couldn't agree more with the court. But in our papers at the end, the bottom line that we were doing is just representing our party at the end. That's simply what I would suggest to the court.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. As already alluded to, the entirety of the legal briefs on the motion below, the order of which is on appeal here, were excluded from the appellate record. And for that reason, this case should be dismissed. And that's just simply from a plain reading of the CPLR, requiring the appellate record to, requiring meaningful, essentially not having those legal briefs precludes this court from having any meaningful review of the decision. But insofar as they're also arguing whether or not willful and contumacious conduct was properly decided by the lower court, that issue is also not on appeal. The prior order, the conditional order, which was issued on February 28th of 2020, that should have been appealed if they disagreed, and those motion papers also are not in the appellate record as well. And for those reasons, we believe the court should affirm the lower court's decision. If there are any questions.
I think we got it. Thank you so much.
Thank you.
Capstone versus Shames.
Thank you.
You may proceed.
Good afternoon, Your Honors. My name is Gary Stahl. I represent the appellant, Capstone Business Funding, LLC. We seek reversal of the order below, which granted respondent's motion for summary judgment and denied Capstone's motion for summary judgment. Your Honors, this is a factoring case. It involves short, straightforward estoppel agreements that are common in factoring arrangements, and it should proceed like a factoring case based on long-standing principles under New York law that require enforcement of estoppel agreements according to their terms. The evidence here...
How do we deal with the issue raised concerning that the transaction is alleged to have been permeated by fraud from its inception?
Your Honor, there's no allegation of fraud per se. The allegation...
I'm sorry. He signs a contract, gets the money, and within a few days puts it in his personal bank account to pay for his mortgage That
Your-
sounds like sufficient facts to me.
Your
Isn't
Honor,
that this case?
that is not this case.
Sorry. You see, too many of these. Go ahead.
Your Honor,
I have another one similar to this
Well,
one.
counsel,
Go
let
ahead.
me ask you another question. I understand correctly from reading the briefs that both parties agree that part of the court's, the decision, the trial court's, the motion court's decision that dealt with the UCC, everybody sort of agrees that that portion of the UCC does not really control here. But there are estoppel agreements in this case, which are a little bit unusual, and could you talk about them and how they play into this whole situation?
Your Honor, well, yes, Your Honor, you hit the nail on the head. It is perhaps a rarity, but both sides agree that the rationale for the order below is erroneous. And UCC section 9-403B does not govern this case. It does not provide the rule.
Well, we're happy that you can agree on something, so we'll go on to what you disagree on.
And just before we leave the UCC, Your Honor, we go a little further. There is no other provision under the UCC that gets respondent to the defenses that it wants to assert. What the UCC 903 subsection F refers everyone to is that the UCC does not displace law that gives effect to an agreement by an account debtor, in this case it's the respondent, not to assert a claim or defense against the assignee. That is capstone here. And here, Your Honor, that means that the UCC, first of all, it doesn't apply. Second, it refers us to the substantial body of New York law that enforces estoppel agreements as they are written. Now, there is one defense that respondent is asserting, and that is that the underlying transaction was illegal. And what this was is a subcontractor in California that issues invoices to the respondent, assigns those invoices to capstone. And in California, there is a statute that bars an unlicensed contractor
Right.
from recovering on that.
And that's what it turned out. After they signed the contract, they found out he had given a fraudulent license
Correct.
number.
5 months after the subcontractor signed the contract with respondent. And in the meantime, respondent signed 6 estoppel agreements with us that waive defenses, that say we will pay, and that say that New York law and jurisdiction will apply.
But,
Now-
excuse me, counsel, but Capstone didn't rely on the estoppel letters to give the money to the plumbing contractor company. The estoppel letters came after the fact.
Oh, no, Your Honor, that's the evidence is to the contrary. All of the undisputed evidence is that Capstone presented the invoice, the assignment, and the estoppel letter to respondent as one package, and Capstone did not release any funding until that was signed. And so it was reliance on the signed estoppel letter by which Capstone releases the funds and purchases the assigned invoices. That's how it worked. There was reliance all the way through. Capstone does not give money until we have respondent's signature on the estoppel agreement. Your Honor, I see my time is up.
You have any other question? Okay. All right.
Thank you. May it please the court, I'm Scott Schaefer, representing defendant, respondent, James Construction Company. There was fraud committed in the underlying transaction in that a fake license number was given to my client. The timing, I disagree with the description of the timing. This underlying contract between my client in which they received the fraudulent license number was in June 25th. The illegal contractor very quickly, within a month, assigned these to his client, Capstone, and the assignment, if you look at the agreement, the invoices were purchased on July 25th.
I thought it was after.
So the invoices were purchased on July 25th. That predates that predates any estoppel letter, so there could be no reliance on that. They were already purchased.
Yep.
Under the terms, under the terms of the assignment, there are three ways to get to where I want to go. Number one, I think the court, although it did have the long section in the underlying opinion about Section 403, I think the final section where it relied on the Abensa cases, line of cases, is correct. What really this transaction, what's underlying this transaction is an assignment. And Capstone is seeking to have a better position than its assignor, which it cannot do.
And it should really stand in the shoes of its assignor, correct?
Should.
Is that your position?
It should, that is our position. And it received an assignment, unfortunately for them, it received an assignment of a void invoice, not voidable, but a void invoice. So its rights, his argument is asking you to elevate substance.
Does it matter that it's void in California, it may be treated differently in New York, so do we still have to consider it as a void agreement?
I'm sorry, I don't understand. Can you?
In California, a contractor without a license cannot do a work on a commercial construction, which I believe this was. It was working on some
Correct,
mall
and cannot
in
get
California.
paid, even if it does the work.
But is the law in New York the same? Can
don't
a
think the law in-
contractor, and does it matter for our evaluation of this decision?
I don't believe the law is the same in New York, but I do not think it matters because New York law will recognize out-of-state laws. So there's a case cited in my brief, Corte versus AB Stars. It's a boxing case that I'm familiar with. And regulations for boxing were different, differed from state to state. And the conduct here, the construction, took place in California. And it's clearly illegal under California law. And New York, New York law is irrelevant to that because the conduct occurred wholly outside of New York.
But isn't there somewhere in the agreement that says that this has to be, that any problems, any issues that arise from the agreement have to be dealt with by according to New York law in a New York court, and that's why the case was dismissed in California against, I guess that was your case against Capstone?
I'm sorry, I didn't really hear you, I'm sorry. But the case,
There was a case in California, correct?
there was a case in California, yes. And we obtained, and that's the second part of my argument. We obtained a judgment that exceeds the amount of the claim in this case. And if you look at UCC 404B, it says that notwithstanding anything else, we can use that judgment, that claim as a set-off. That's the second part of our argument, that 404B clearly applies to this case and sets off any judgment. And in this case, the amount of the claim exceeds the amount of our claim exceeds the amount of their claim. That's pretty clear. The third thing, I see that I'm running out of time. The third thing is that even if you do reach the issue of whether these estoppel agreements are enforceable, I don't think you need to get there because of the Abensa case and the logic therein, but they are not enforceable. We just discussed earlier how there was no reliance on it, and additionally, besides the lack of reliance, there's a lack of consideration because there's no representations in the estoppel letter made by Capstone. So we did not receive any consideration for that signature on the line. So for two reasons, I don't think you need to reach that issue, but the estoppel letter is unenforceable for lack of consideration and lack of reliance. Do you have any other, I have a few seconds left. Do you have any other questions?
No?
I would just close by saying, if he wins the case, New York becomes a haven for the enforcement of illegal contracts. In other words, this was a case where an illegal contract was made and very quickly assigned to a New York entity. In the home state, this was clearly unenforceable, and we should not have a rule of law where someone can, within 1 month, turn it over to a different state and collect for something where the underlying object is clearly illegal. And I have cases cited to that in my brief. Thank you very much.
Thank you. Hey, counsel, you have 2 minutes.
Yes, Your Honor. With respect to the chronology of these events, the agreement between respondent and the subcontractor was late June. The first assigned invoice was several weeks later during the first week of July. That agreement was in place before any assignments took place. And Your Honor, under their agreement with the subcontractor was required to produce a copy of its license. Respondent never asked for a copy of its of the subcontractor's license for 5 months. And in the meantime, it entered into 6 of the estoppel letters with us and paid 3 of them in full. Your Honor, the contract the estoppel agreements are short, they are straightforward, with a promise to pay and a waiver of defenses. The respondent's argument rests in large part on the stands in the shoe adage. It's a rule of thumb, we've all used it, but it is shorthand nonetheless. And it's short on perspective, and here the perspective is, it assumes, the shoes of the assigner assumes that all elements of the transaction are operating under the same legal framework. That's not the case here. The subcontractor and respondent, in their work, on their construction work, were proceeding under California law. When respondent signed the estoppel letters with us, and they signed a total of 8 of them, and their CEO signed 3 of those, it said New York law applies. Respondent knew what it was getting into. And in fact, it was so sensitive to New York law that respondent sued us first in California. The California law, the California court dismissed and said, basically, you've gotten into these agreements, they're enforceable, and go to New York.
Thank you.
Thank you, Your Honor.
Rosa versus 47 East 34th Street. You may proceed.
Thank you, Your Honor. Christopher Savro, Pollock, Isaac, and DeSico on behalf of the plaintiff appellant. I guess I should note, just as an initial matter, it seems that it's been conceded that there was at least one error in the trial court's decision, and that is whether or not the plaintiff was engaged in a covered activity at the time that he was installing the bus duct. It seems very clear that we put forward several cases that said, this was a complete reconstruction of the building. It was part of a punch list settlement to do one last task. It was all part of the same project, and if the project was covered by the labor law, then this activity would be as well. If Your Honors would like to address that point, though, I'm happy to.
No?
Okay, it seems that the very main point of contention is whether or not the plaintiff can rely upon her testimony regarding her conversation with the superintendent at the hospital. And I think that—
Has there ever been any indication of who that superintendent could have been other than Mr. Cuevas?
No, Your Honor. Mr. Cuevas' testimony, as well as that of Ms. Hewitt's, are categorical in that he was the only superintendent on the premises at the time. I don't think that there's any genuine dispute that he was the superintendent in question. And when she—
And there's no question that he came to visit Mr. Rosa when he was in the hospital, and the daughter spoke to him there.
Correct, Your Honor. That's our position. And defendants argue, well, why didn't plaintiff's counsel set this up at Mr. Cuevas' deposition? And I think my response would be, the balance of my career since 2008, over half of it was on the defense side. And why didn't the defendants prep the exact same question? If Mr. Cuevas did not make these statements, plaintiff's daughter was deposed first, they should have addressed it at the deposition too. That argument cuts both ways, and I don't think that anyone comes out ahead there, especially because it's their burden of proof in the first instance to show that it was not Mr. Cuevas that had this conversation with her. Now, she also spoke with the foreman as well, and the foreman provided indications to her that corroborated what her own father had said to her, that he was supposed to work on live wires. That's what her father told her directly at— And
was that because the people at June Electric who was his employer, I think after lots of litigation, that's been determined, said to him, look, there's going to be an inspection tomorrow, you got to get over there ASAP, maybe use different terms, and get this done.
Yes, Your Honor, probably more colorful terms than that,
That's what I
can
meant,
imagine.
but we'll keep it at
Yes,
that.
they were subject to a settlement, and CIM was on the hook for that as well. They were the signatories to that settlement agreement. They were the ones who are going to be paying $34,000, as stated 697 of the record. Your Honor, do you have a question?
Yes. Where on this record do you establish a material issue of fact in opposition to the defendant joint and several claims that the opposition comes from hearsay and no other independent evidence?
Well, Your Honor, I believe that it comes from a few different sources. We discussed Mr. Cuevas' testimony as well, that he could have locked the bus duct and he did not. I would also point out that their contention is, well, Mr. Cuevas he had said, I was going to come back, I'm going to shut down the power. However, if we look at Ms. Hewitt's testimony at pages 419 through 420 of the record, she states that if there's going to be an interruption to services of water or electricity, the superintendent is supposed to advise the tenants of the interruption and for how long it will last.
They have to notify the tenants. They can't just shut it down in this big building.
Exactly, Your Honor. The tenants rely upon these services, and they're not going to shut it down without providing tenants notice.
And she was very clear that she did not get any such indication from Mr. Cuevas prior to the date of the accident that there would be a need.
Correct, Your Honor.
That he intended to shut off the electricity.
Yes, and I know that the main concern with hearsay is the reliability of it, but I would posit that
Among
Ms.
other
Hewitt's
things.
among other things, yes. But I would posit that Ms. Hewitt's testimony bolsters the reliability of the hearsay in this case.
What about the help?
But it also creates an issue of fact, because we have one witness, Mr. Cuevas, who said, I was going to come back from the store and turn off the electricity, and Ms. Hewitt, who said that under no circumstances was Mr. Cuevas allowed to turn off the electricity without their knowing about it and having provided the tenants with notice.
Correct,
Am
Your
I
Honor.
Incorrect about that?
No, Your Honor, you're perfectly correct. I'd also add that the defendants argue in speculative fashion, which under Zuckerman versus New York is of zero evidentiary value. But they argue, well, he wanted to make the interruption as brief as possible, so he was going to run to the store, however long that took, then come back with the added equipment, and then shut off the power. But if that goes to the reasonableness of the defendant's conduct. Doesn't that create an issue of fact too? Was it reasonable for him to delay in shutting off the power when that put the plaintiff at higher risk? Which is a more reasonable concern? The inconvenience to the tenants or the potential to have an explosion that would kill somebody like the plaintiff? Luckily, he wasn't killed directly by this. He ended up dying several months later, tragically, but the concern should have been for his safety, and I think that the broad purposes of the labor law directly support that contention.
Thank you.
Thank you, Your Honors.
You may proceed.
Good afternoon, Your Honors. Christopher Simone for the defendants, 47 East and CIM. I don't think the parties are in dispute that if sole proximate cause defense, as the court found, is applicable, then all the claims should have been dismissed. I don't think we're
Well, there's a
disputing.
big issue about sole
Well,
proximate cause.
You know, Judge,
so-
I have to respectfully disagree with the big issue and a few things. First of all, I don't disagree with.
Who left the door to this electric room unlocked? Who did that?
Cuevas left it unlocked because that's where the work was going to take place, but he told plaintiff,
But the work wasn't going to take place until he got back.
correct, and he
right?
didn't give him a ladder to do it either. It was 15 feet up.
Well, I don't know how the ladder got there, and neither does Mr. Cuevas.
Well, according to OSHA, he took it from the boiler room himself.
All of that was based on hearsay, right?
Well, no, Your Honor, that was part of the investigation. But I don't disagree with hearsay can be used in opposition to a summary judgment motion, provided it's not the only evidence. But plaintiff didn't rely on hearsay in opposition. They had no evidence in opposition. They're doing it for the first time on appeal. That's the problem.
Except that
wasn't
the defendants here submitted plaintiff's deposition. And by doing so, You have accepted those statements.
Those were her statements, but she's never established who this superintendent was. She didn't know who
Do
it
you
was.
have another superintendent other than Mr. Cuevas at the time of this accident?
I'll tell you why I don't have to, because, number one,
What do you mean you don't have to?
because in her motion, she distinguished between the superintendent at the hospital and Cuevas, the resident manager, 710 to 711. She distinguished between the two. She never argued they were the same person. She didn't argue anything like that.
Did she ever say that the person she spoke to on the phone she had met personally prior to that?
Pardon? I'm sorry.
I don't believe she had met this person. The person she spoke to on the phone, she had never met personally until after the accident.
But she claimed that
Is
this...
that correct?
I think you're correct, but she claimed that this superintendent had a personal relationship with Cuevas. There's no indication such as that in Cuevas'
Again, this is all hearsay.
Right, but Judge, they're relying
So
on it for
that
the first
doesn't
time.
prove anything.
Judge, but that's right. They're trying to do it for the first time on appeal. And in any event, the statements that she's saying, they don't raise an issue of fact. Everybody knows he worked on a live bus duct. That's the problem. He shouldn't have been doing that. We know that already. That's not an issue. And there's, contrary to what plaintiff's trying to represent.
Can you explain to me why the building was unaware, according to Ms. Hewitt, who is running the program in the building for the travelers, right? According to her unrefuted testimony, she would have had to be notified by Cuevas if there was going to be an interruption of any kind.
Yes. He cited page 420 of the record. 435 of the record, her testimony, it was only for a major disruption, not a minor disruption. He was purposely trying to...
Well, turning off electricity in a big building like that is not a major
2
disruption.
minutes. It was 2 minutes. That's the problem.
If
It was 2 minutes. That's what he said. It was a 2-minute job.
What expert affidavit is in this record that tells me how long, what work had to be done, exactly the mechanism of that work? Explain to me how a 4,000 amp explodes. Right?
It doesn't...
I have nothing in the record to explain to me
Judge,
anything.
but it doesn't, because none of that matters. In support of summary judgment,
And
we
if I
established...
disagree with you, is that a shortcoming of the defendants?
It's not a
Since
short...
you are the movement.
Judge, we established in support of summary judgment that we told him not to do this work. It wouldn't have... This is why it's sole proximate cause. He put nothing in opposition. He put argument. The only thing he argued on 241-6 was because he was electrocuted, it's a violation of statute. That's not true. Every labor law provision begins with suffer or permit.
Was he an electrician?
Yes,
He was?
he was an electrician.
Is there a license referred to anywhere in this record? I didn't see one.
Judge, he's an electrician for June Electric. I mean...
Counsel, I don't take anything for granted.
Judge, nobody disputes.
okay?
That's not
I
disputed,
don't
Judge.
understand that every person who works in an electrical company is an electrician. I don't know that.
But Judge, plaintiff never argued he wasn't an electrician. These are not arguments that they raise in the motion. Read the motion. On this record, this was the sole proximate cause decision was correct. There's nothing in opposition. They're trying to do it now. I understand why they're trying to do it, but it doesn't work.
Okay,
Even if
you're
you
out
put
of
the-
time.
Thank you.
You'll have time on rebuttal. Next.
Good afternoon. May it please the court. Eliza Scheibel for the defendant, Bridge Street. Your Honor, I want to address your question about leaving the door unlocked. That was not unreasonable under the circumstances after he had instructed him that he was going to run down the street.
The only person who says that he instructed him is him. So I am, we're seeking to affirm a summary judgment finding on the basis of his own statement, because nobody else corroborates that.
Well, Your Honor, Anna Rosa testified that her father talked to her about the accident, and in that she does not say that he ever told her that somebody instructed him or that Mr. Cuevas instructed him to do it with the electricity on. So the the decedent did not claim that he was instructed by Mr. Cuevas to do it with the electricity on. Mr. Cuevas said he arrived, intended to do it with the electricity on with cardboard, and Mr. Cuevas said, no, I'm going to go to the store and get rubber padding, one safety measure, and I'm going to shut the electricity off. Ms. Hewitt testified she would only be notified about a major disruption of services, that if there was a minor disruption, 2 minutes, 5 minutes would only be a minor disruption, that then she wouldn't be notified. Here, Mr. Cuevas says, I'm going to go get this part for you. I'm going to run down the street. I'll be right back. And leave expecting someone who'd worked with electricity for 10 years. Mr. Cuevas testified that Mr. Rosa agreed that he would wait to do it.
The fact that your own witness said that Mr. Cuevas described the plaintiff as a gung-ho employee, he was a bit of a cowboy, et cetera, et cetera. So in light of that, it's still not unreasonable for him not to have closed that door, knowing that about him?
In light of the fact that Mr. Rosa agreed that he was going to wait to do the work, yes, and wait for the material that was going to be used in the work, yes, it was. If the work is only going to take 5 minutes, it's not unreasonable to think that someone's not going to do that while
Counsel,
they're waiting
Mr. Rosa was prepared to go forward, right? I mean, in a fashion that Mr. Cuevas didn't like. He was going to use cardboard, so he was ready to go forward, and Cuevas knew that.
But Mr. Rosa had agreed that he wasn't. I don't think it's reasonable for Mr. Cuevas to have assumed that Mr. Rosa was lying when he said, yes, I'll wait, go ahead down the street to get the rubber padding. So I don't think it's reasonable to assume that somebody who's been
And in terms of
working
the interruption, there are about 30 floors in this building, correct?
approximately, yes, I said over 30.
So you're telling us that it's a minor disruption if electricity is shut off to the entire building, affecting the elevators as well, that you will classify that as minor?
I believe that under the testimony of Ms. Hewitt, that is something that she was classifying as minor. Major disruptions she described as things that were shutting off utilities of the building, I believe, for several hours. That if there was a minor disruption to service, something less than that, that no, she wouldn't have been notified. They would have handled it within the building. And I think we also cited case law in our brief that merely leaving a door open is not a negligent act, and it's not the proximate cause. It's merely a condition that allows for the occurrence to happen. And there was nothing, the plaintiff, prior to this appellate brief, has never alleged that it was Mr. Cuevas who supposedly made these statements at the hospital. She specifically relied on Mr. Cuevas's testimony to argue that he had control over Mr. Rosa. So she did not, in the motion papers below, ever allege that there was evidence contradicting that Mr. Cuevas told Mr. Rosa not to work on it.
But is there anybody else that there was a super on the premises at the time that this super could have been?
But that's accepting Ms. Rosa's testimony that this person told her that she was a super. We have no idea who she was talking to. She says she was talking to the foreman from...
Is that because there's only one super, Mr. Cuevas?
Mr. Cuevas described himself as the resident manager, and he also testified that there was another handyman who worked with him on occasion.
A handyman and a super are two different things.
Speaking of that, the helper, was he ever identified by anyone?
I don't believe that he's ever identified in the record, Your Honor.
Who would know that information, though?
I believe that would have been someone who came with him from June Electric.
But isn't that something that I think all parties here would be interested in knowing who was Mr. Rosa's helper?
I was sure I don't know why that information
Because it seems to me at least, and I think we agree, that he's the only one that knows what happened.
And the information that he provided to Mr. Cuevas was that they...
All hearsay.
Hearsay.
I mean, that is never going to be, if there were a trial here, that evidence would never go before the jury, because it's pure hearsay.
I think...
Double hearsay. So, we have this huge hole of lacking information and lacking witnesses. I find it really, really convenient that this witness, nobody knows his name, and nobody has identified who this other super in the building was. But that's okay. Next.
May it please the court, I represent the third-party defendant, June Electric.
So wouldn't
I was
wouldn't-
present at-
Excuse me, before I forget, wouldn't it be your client that would know who was the helper that went with Mr. Rosa on the day of the accident?
I just want to advise the court, I represented June Electric from the first, I put in the answer in this case. I represented them at every deposition. About 3 months after the case was started, the principal of June Electric, James Arsenio, passed away. He never provided any documents to my office. This wasn't in this record, but it is in the, something that occurred. And so that's why we do not know who his assistant was. We did not know his...
And we can't confirm that this Mr. Arsenio sent this man over there to do this job with a live electrical output going on.
Oh, we can confirm that. Mr. Cuevas has testified that when the plaintiff showed up, the power was on in the building. He was there to do some mop-up work on a work order that is in the record. So we do know that. And we also know that he was told not to do the work with the power on. He agreed to that. And then when they were out getting a piece that was necessary to do the work safely, he went and did it anyway. That's the testimony that we do know about. Now, on the hearsay testimony, I don't believe
That's only if we accept that Ms. Hewitt says that the shutting down of the electricity is a minor inconvenience, right?
Correct. He said it would
Because
take...
that conflicts directly with Cuevas's testimony that he was just going to run out and come back with this additional piece, and he was going to shut it off just for a little while.
Correct. That it would
Without
only
notice
take-
to the tenants, which is
It
what
was
is
just a
required,
place...
right? Without notice to the tenants, which is what is required.
Correct. That's what Mr. Cuevas testified in this case under questioning from plaintiff's counsel and the other parties. Correct. Now, the hearsay testimony that plaintiff is relying on actually doesn't even rebut the proof that was put on the case. The testimony was that the foreman from June Electric had told her that my father was working on a bus stop live and that he got electrocuted. That's what Mr. Cuevas has testified to. It's totally in line with that testimony. That whoever told her this, the superintendent of the building or the superintendent, told her that pretty much the same thing, that he had been working on the bus stop live and that it was to put on an end cap. They had an inspection the next day, and so it was important that my father got it done before the inspection. That's why he was there, to do that work that day. That would only take 2 minutes. If he had waited for Mr. Cuevas to come back and turn off the power, he would have done it safely. So this testimony doesn't even rebut.
Is there testimony of someone with actual expertise in electrical work that has confirmed in this record that job would have taken only 2 minutes?
No, there isn't.
Okay. I didn't think so.
But he was there to do the job that day.
I understand that.
Okay.
That doesn't tell me anything about exactly what it entailed.
It was to place an electrical bus stop that was the only thing. The building was operating. The power was operating. This was mop-up work that the building had gone bankrupt, and that's why the work was not completed. So for years, this building had been operating without that bus stuck up there. So this wasn't like a major job. It was referred to as mop-up. If you look at the...
Except that there was going to be an inspection the next day. So that was the fire that needed to be put out, no pun intended.
No fire to be put out. If you coming in on Monday, because an inspection is done Tuesday, where's the fire? If this guy didn't
He was
do the work...
counsel, I really don't appreciate your tone with this court.
Sorry.
Okay?
Beyond that issue, I just want to raise one more. I am the third-party defendant in the case. I move to dismiss the common law claims alleging that there was no grave injury, which was what the pleading said against me. Because of the wrongful death of this gentleman, there was a grave injury. I believe I've put in satisfactory proof that he died of natural causes. In a prior order of the court...
Is it true that at the workers' comp, there was a concession by the parties that this decedent died in part, at very least, of his injuries? I believe that's what was conceded at the workers' comp.
I do not believe it is, and I do not believe that it's the same standards either, Your Honor, for a grave injury in the workers' comp. I believe there's
Well,
case law about...
and wrongful death is not the same standard as grave injury either. So the fact that an amendment for wrongful death was denied does not speak to whether there was a grave injury, right?
I believe it does if he died from natural causes, hypertension, cardiovascular...
That wasn't my question. My question was the fact that wrongful death amendment was denied does not equal that the court made any determination about grave injury.
No, they made a determination on wrongful death, which was what the pleading, the third-party pleading specifically alleged grave injury because of wrongful death. No, I did not oppose every other ground of grave injury about his missing a limb or number of fingers and things of that nature. No, I did not, Your Honor, because of the pleading itself. Thank you.
You have a minute on rebuttal.
I'll be brief. I just want to quickly address a misstatement of the record made by Counsel for June Electric and Counsel for Bridge Street. Counsel for Bridge Street said that no one instructed the plaintiff to undertake the task, and the Counsel for June Electric said that it wasn't accurate that he was instructed to work while the power was live. I'll direct the court to page 269 of the record, where the plaintiff, Ms. Rosa, testified that her father also said that he was the only one that was willing to do the job, and that's the reason why they called him, and that Jimmy knew. Jimmy was the owner of June Electric. That page indicates that Jimmy knew that the power was going to be on. He was going to have that his workers were going to have to work with the power on, and that he knew that the decedent was the only one who was going to be willing to do it. Now, I would also like to address something that June Electric said, that the Cuevas said that he left to go retrieve a piece of work, a piece that was necessary to do the work safely. That's not accurate. It was just something that they were going to install to the bus duct. What was needed to do the work safely was to shut off the power. Let's be perfectly clear about that. And then
The defendants' counsels spend a lot of time in the briefs talking about how a lot of the arguments we're making here were not made in the motion court below.
correct, Your Honor,
And that
we
we
don't.
shouldn't even be considering these discussions about some of the past testimony. And can you just address that? Because that's preliminarily something we have to look at.
Of course, Your Honor, and we addressed that as well. We conceded that the hearsay arguments were not made as directly in the papers below, but there's the well-trod-out case law that where the facts appear on the face of the record and it's a pure question of law, then that can be raised for the first time on appeal. And as Justice Manzanet pointed out earlier, they had submitted the testimony in question. It appears on the face of the record. Whether or not a hearsay exception is found upon the record evidence, that's a pure question of law. We're not relying upon facts outside of the record, which I think that the whole line of cases addressing whether or not there's a pure question of law is designed to do. We're not saying, well, let's go and hold another hearing. And we're saying, no, it's very clear on the face of her testimony and the face of the defendant's testimony that there's one superintendent. On that note, I should note that there is
Counsel, you're out of time.
Oh.
Thank you.
Thank you, Your Honors. Have a good day.
Very briefly, Your Honors.
Have a minute.
On the hearsay issue, this is not an issue of law for the court. This is a completely factually driven issue, and it's really ambushed because had this been explored, discovery's closed now. We could have, had Cuevas submit an affidavit as to who is the superintendent? Is there a superintendent? Well, who is it? That kind of, and he was never at the hospital. It's not fair now to accept these statements. The summary judgment record we submit is sufficient to find sole proximate cause here. Merely because plaintiff doesn't have a means to oppose it with admissible evidence doesn't mean that the standard is somehow heightened and additional information is now needed on our part. The record establishes that he did this work when he wasn't supposed to be doing it, period. That's sole proximate cause. And once you have sole proximate cause, it's dispositive of the entire claim. He can't come on appeal now and start to, and plaintiff was smart to hire Mr. Isaac's firm to do this because they're trying to make something out of nothing. But it's not fair to now come on appeal and raise brand new issues that were never explored, claims that were never made about two people being the same person for the first time on appeal when there's no opportunity to explore that. Thank you very much.
Your Honor, just two very brief points, just to build on what counsel was saying. We cited a number of cases with respect to waiver, all of which hold that you may not raise a new exception to hearsay on appeal because they are very fact determinative. The cases cited by plaintiff, none of them deal with hearsay exceptions. I don't think they've put forward anything showing that a new hearsay exception should be considered on appeal. And the only other point I wanted to raise, obviously we have argued that the sole proximate cause issue is determinative of all the issues here. Bridge Street did meet its prima facie burden, and plaintiff did not rebut that. To the extent the court disagrees and there are claims still remaining from plaintiff against the defendants, we think it would be inappropriate for any of the third-party claims.
I agree with you on the issue you started with, but there are also cases like Muller Street Sire versus New York City Transit, which says that where a party waives the hearsay objections by failing to object before the motion court, but also by relying on them in support of their own motion, then the issue of you can't consider that evidence because it's hearsay is waived. And here, the defendants submitted those hearsay statements of the plaintiff.
I don't believe those portions of the plaintiff's testimony were relied upon, but I understand what Your Honor is saying.
Once
but
you
I don't
submit
think...
it, now you can't pick and choose which hearsay statements from the plaintiff's deposition you want to use, and then the rest are hearsay. Once you submit them, they're all in. So why, if that is the case, why is there not enough for an issue of fact here?
Because, Your Honor, even if we were to consider the argument of the hearsay exception, it's plaintiff's burden to establish that exception as the ones offering the hearsay, and
But they don't have to, because you've waived it by introducing it in your own papers.
Your Honor,
That's what the case law says.
I'm not familiar with that case. I think that the waiver does apply here, and I don't think they can show that these statements are connected to Mr. Cuevas, and I think the fact they never even argued that below is indicative of the fact that it may not have been Mr. Cuevas, because if it was, they clearly would have stated it. And the statements with respect to plaintiff saying that it did rebut the testimony because Jimmy knew the power was going to be on does not rebut Mr. Cuevas's testimony that he instructed Mr. Rosa not to perform the work with the electricity on and that he would turn it off when he got back.
Except he's the only one saying that.
He was the
I have
only...
no other evidence to that effect.
Your Honor, but that is the evidence, and that satisfied our prima facie burden, and it was not rebutted.
Okay.
Thank you.
Again, Your Honors, I'd just like to say, or ask the court, to look at the exact quotes that the plaintiff is saying rebut this testimony. It's all hearsay, it's all agreed, but none of it rebuts what Mr. Cuevas testified to in this case. That he told the plaintiff not to do the work, that he left to go get the part, and before he came back, the plaintiff decided to do the work with the power on. But for him doing that, this accident would not have occurred.
Okay.
Thank you.
Thank you. People v. William Mullen. You may proceed.
Thank you, Your Honors. Good afternoon. My name is Elizabeth Caldwell from the Center for Appellate Litigation on behalf of Mr. William Mullen. May it please the Court. I plan to briefly address the sufficiency of the evidence with respect to physical injury, as well as the Court's denial of the intoxication charge. The respondent has conceded on appeal that the worst injuries the complainant reported were not the result of pressure placed on his throat. And as a result, those injuries, which were on the back of his head, his hip, his back, and his elbow, cannot be considered by this Court when assessing whether there was sufficient evidence of physical injury here. What remains does not meet the penal law's definition. The tiny bruises on the complainant's face and neck and the superficial red marks on his neck are not enough here. He didn't seek medical care for those injuries. He never
Excuse
testified.
counsel, didn't the plaintiff testify that he was in pain for approximately 2 weeks? He couldn't swallow. I mean, it lasted more than just the day, and the injuries and the existed for just beyond that day, right?
The bruising did last for longer than that day. We don't dispute that. But there was no testimony from the complainant that that continued to cause him pain, it caused him to miss work, or anything like that. In terms of the testimony about
2 weeks of pain that is not petty or slight is enough.
Your Honor, the testimony was not that the pain lasted for 2 weeks. It was that the markings lasted for 2
He
weeks.
said he couldn't eat, that it was painful to swallow. I mean, I've had cases where they say nothing, so,
Right,
but this isn't one of them. I mean, he could have said more, but
understood.
this is not one of them.
I would just say that in terms of looking at the actual medical records from the night of the incident, he goes to the hospital within hours, and at that time, he says that there was pain on his throat, but the doctor finds that there was a full range of motion without any pain at that time. He reported no problems breathing, no problems swallowing, no problems talking.
Well, I mean, maybe he didn't realize he was having problems swallowing then because it was right after the event. I'm not sure if he felt that he was almost choked to death. Maybe eating something was not his first choice right afterwards. But he did testify, and the jury was able to consider the fact that he had pain the pain while eating continued for 2 to 2.5 weeks. And also he said he could not sit down for a week or week and a half because of the pain in his hip because of when he was thrown down and hurt. So, I mean, there was testimony that the jury was able to consider as to the pain that he had for a week to 2 weeks.
I'll just say one point about the pain on his hip. The people have conceded that that's not part of what we're looking at here because it wasn't actually caused by the strangulation as the penal law requires. I would like to turn, if I may, to the intoxication charge. Here we have evidence from Mr. Mullen that he was not used to drinking and that he's basically been drinking for an entire night. He had 2 scotches, he drank champagne for hours, he drinks wine at this apartment.
I read that, and it did sound like an awful lot of alcohol. He was a big guy. It still sounded like an awful lot of alcohol. But the thing was, didn't he also testify very clearly that he had an intent not to hurt him, but his intent was to embarrass him, to intimidate him, to keep him down. He testified very carefully about his plan, his intent, and what he did. If you're intoxicated, you wouldn't remember any of those things. So it seems to conflict.
Your Honor, he does testify about what he believed in the moment as he's drunk. He's perceiving this incident. But he also said to the jury that his intoxication did impact his actions that night. He says that it affected how he's interpreting what the complainant is doing.
But that's not the standard, right? The standard is not that it impacted my actions, right? That's not the standard.
Understood, Your Honor, but I do think that this meets the low threshold when you view this evidence in the light of the defense, in favor of the defense, that this meets the standard that there was sufficient evidence of intoxication in the record for a reasonable person to entertain a doubt as to the element of intent, because he's here, he's telling the jury.
Counsel, aren't you asking us or asking the jury to sort of believe it, to take it both ways, right? In 2 contradictory positions. In one hand, you're saying he's so intoxicated that he can't form the intent to strangle the victim, right? But on the other hand, you're saying that despite this intoxication, he purposefully put his hands around Mendoza's throat in a manner in which he would not obstruct his breathing, and that he did it repeatedly with the sole purpose of dominating and controlling Mendoza. So you want us to believe that he has that requisite intent, but not the intent to strangle?
Your Honor, what he testified to is that he remembers in his mind as he's drunk that he's doing a set of actions that he believes, again, while drunk, that this will not cause some outcome. And that his intoxication affected that intent, that his goal was to intimidate someone. I see that my time is up. I'll address the rest of your questions on rebuttal. Thank you, Your Honors.
Thank you.
May it please the court, my name is Patricia Kern, and I represent the people on this appeal.
Well, counsel, was he so drunk that he couldn't form the intent to strangle?
No, Your Honor, there was evidence by the defendant of what he had to drink that day, and in fact, the victim said that he thought the defendant was drunk at some point. However, during his trial testimony, the defendant recounted in detail everything he was thinking about and what his intent was when he attacked the victim here, talking about more than once, numerous times, that he attacked the victim to control him, to intimidate him, and oddly, to get him to leave. So it was clear that whatever he had had to drink did not undermine his ability to form the requisite intent here. Any doubt of this is resolved by the video here, which shows the entire attack in clear detail, and it's plain that he is not intoxicated when he is actually attacking the victim. He has great feats of athleticism in the way he grabs him and throws him to the ground and then holds him down by the throat for what the defendant estimated was about 5 minutes, applying additional pressure at least 6 times. And all of that is corroborated by the video as well. Are there any questions about the physical injury element here as to the trial evidence? Counsel says that the people have conceded the other injuries aren't relevant. We haven't conceded that. Obviously, all of the victim's injuries here were caused by the defendant. There are some of the injuries here where there is an absolute direct nexus from the defendant applying pressure to the victim's throat. And so the court, if it doesn't want to, doesn't really have to reach whether the pain that the victim suffered when the defendant threw him to the marble floor was part of the strangulation, because there was evidence of the petechiae to the face and neck. He testified about his dizziness. At the hospital, as Your Honor said, he said he had difficulty eating, he was in terrible pain, and then the marks and the difficulty eating lasted for several weeks. If there are any questions about this or
Counsel,
about
just
the expert
with the
testimony?
expert, why should have the trial court allow the expert testimony about unarmed combat?
I'm sorry, Your Honor, I missed the first part of your question.
Should the trial court have allowed the expert to testify with regards to his expertise in unarmed combat?
Should she have allowed it? Is that your question?
Yes.
No. Obviously, the court should not have allowed it here. The expert here wanted to testify to unarmed combat. The court decided that that was not beyond the ken of the ordinary juror. These were supposedly 2 men fighting. If that were the case, the expert really had nothing to add. But in fact, there was no combat here. This was a much larger man brutally attacking a much smaller man. The smaller man wasn't fighting back at all. And in addition, the court obviously didn't abuse its discretion, listened to what the proffer was by defense counsel, and she actually listened to the testimony of the expert. When she listened to the testimony of the expert, she found that what he based his testimony on, his police training and his martial arts training, when we find that the defendant testified, he didn't have any of that training at all. So there was nothing anchoring the expert's testimony to the facts here as the defendant testified.
Wasn't a major issue with the expert during what I would characterize as the Fry hearing to see if he was qualified? The expert was not in a position to give medical opinions, to somehow link the physical act of placing the web of the hand on the jawline as somehow not being in a position to impede airflow. And much of what he was trying to say is because he really wasn't qualified.
Is your question whether he could give medical testimony?
Well, he was rendering certain conclusions about the maneuvers that the defendant was claiming he was doing here in this circumstance that could not have caused strangulation. Am I correct?
Well, the defense made clear they were not offering him as a medical expert.
I understand that.
So I'm not sure if I'm understanding your question.
The court, in holding that hearing, had to determine the opinion that the retired police officer was giving would be admissible, evident, the opinions, the conclusions. One of the conclusions that I understand from reading the record is that he was going to say that the maneuver that Mr. Mullen used on the victim could not have caused strangulation. Am I correct?
I think what he was going to testify to was that the placement of the defendant's hands on the victim's throat would not have impeded the victim's breathing. I
Correct.
think that's what he was going to
He
testify.
was trying to, and the court determined that he was not competent to make that kind of conclusion in terms of the physiology of it, to be able to determine whether that maneuver would or would not cause strangulation.
I'm not sure she said it in that way.
Well, that's how I interpret the ultimate decision.
The facts show that even according to the defense expert here, even he agreed that the defendant's hand was moving along the
That it would
victim's
slip.
throat. And at some point, the defendant applied pressure, which meant that he was guilty of second-degree strangulation. So it's not even clear on that score that he would have helped the defense. I see my time is up. If there are any other questions, thank you very much.
Thank you.
Thank you, Your Honors. With respect to the expert, I think it's important that the court look closely at the trial court's decision here, because all that the trial court cited as the reason for excluding the expert testimony was because this was not beyond the ken of the average juror. The court never said this was not relevant. The court never said, oh, he's not a medical expert, after basically the entire
Well, he's not.
proffer.
I mean, there's no issue about that. He was not a qualified expert in the area of medicine.
Right, of course, we're not saying that he was qualified as an expert in emergency medicine like the other experts were, but the entire proffer was talking about his understanding of what could happen as a result of the placement, which drew on information about someone's neck. And the prosecution at that point never said, oh, this goes into medical testimony, so that's why he can't testify to that. That was not the basis for the court's decision as to the expert. The court said this is something that everyone just knows by looking at the video, and we've argued in our brief that that was not a proper basis for denying the expert's testimony, and that impinged on Mr. Mullen's right to present a defense. Thank you very much. Oh, did you have another question, Your Honor?
No.
Oh, okay, thank you very much.
N47 Associates versus Gemsco.
Your Honors, may it please the court, I represent Gemsco Realty, the respondent appellant, and we are seeking reversal of the orders below. The orders on this appeal must be reversed first and foremost for the reason that at the December 2020 hearing on N47's petition, N47 disclaimed any relief to which it is now defending and to which it now claims it is entitled on this appeal. At that hearing, N47's counsel repeatedly and unequivocally represented to the court and Gemsco's counsel that it was not seeking authority to remove Gemsco's structures and properties and other property protruding into a disputed strip prior to a determination of ownership of that strip. The following colloquy is an example. And when I read from the transcript, and I'll be very brief, Mr. Hafner is me, I represent Gemsco, and Ms. Reverso represents N47.
Counsel, before you start, can you just repeat the date of that hearing?
December 2020, Your Honor.
Okay.
The court, and Mr. Hafner, how soon can they have access to do that? Mr. Hafner, just to clarify that this pre-construction survey will not involve removal of any of the protrusions, removal of anything. We can provide access within any time within 2 weeks. The court, Ms. Reverso, is the condition of that it will not in any way affect removal of the protrusions? Ms. Reverso, well, I think the pre-construction survey is just a survey to take pictures and document conditions. The court. So it should not have that effect, right? Ms. Reverso, correct. That's at the record at page 472. Later, at that hearing, the court, I asked you, addressing Ms. Reverso, I asked you what you could work on that has no need for the decision, referring to the summary judgment motion on adverse possession. I ask that be what you limit this conversation to at this point. Ms. Reverso, we could ask for monitoring to be installed 1 week prior to the commencement of the excavation. The court, but isn't the excavation subject to the decision? Ms. Reverso, Your Honor, they could start excavation on a different portion of the property. The court, good. Well then, if you need, so then installation of monitoring, and you say 1 week before excavation, other than the area affected by the adverse possession determination where you want to start excavation. Yes? Ms. Reverso, correct. The court, on a non-controversial area, right? Ms. Reverso, yes. Prior to the commencement of the excavation, other than that which involves the disputed area. Now,
But I'm looking at, I know that there was a transcript, but of course there was also a written order issued by Judge Edmead after the oral argument, and she listed a whole bunch of specific relief, and on page 2, in subsection G, she said remove items that they were allowed to remove items that existed from respondent, that's you, from respondent's property and into petitioner's property, subject to this court's determination of respondent's encroachment claims. So she allowed the removal, but still said these are still things I will have to determine during the when she has to consider the encroachment claims, which I think may be in a different lawsuit.
yes, Your Honor, and we naturally, based on the transcript the portion of which.
But you know you can't, I mean, honestly.
I'm sorry?
During a transcript, we've all done long transcripts in trial court.
She's talking.
Yeah, I mean, we've all done long
I'm sorry.
transcripts during oral argument and when we're in the trial court, and we have discussions back and forth, and at the end, we render a decision. We sometimes ask questions just to get some information, just like we do here. Ultimately, what controls is the ultimate decision, not like the colloquy that goes on during an oral argument. So this is what she wrote. This is what we have to, look at.
Well, it's our position that she, based on the transcript, which, by the way, the access order references and says the access order is subject to, it is very clear that the relief.
Counsel, once you got the written order and it strayed from what you believed you were getting, you had two options, which was seek clarification from the court, right? But to argue, I'm following what she said in oral argument in the transcript, that's not going to fly here. We are bound by the four corners of her written order.
Your Honor, we did seek clarification from the court, and we're appealing from that order as well. We were very surprised, given this.
And you'll have time to talk to me about that on your time on reply. I'm going to give you an extra minute to do that, okay?
All right, thank you.
You may proceed.
Good afternoon, Your Honors. May it please the Court, Pia E. Reverso, for the respondent, N47. Your Honors, what we have, the limited issue that is before this Court, is whether or not the Supreme Court properly exercised its discretion pursuant to RPAPL 881, to allow N47 entry to Gemsco's premises to remove the protruding items while Gemsco's claim for adverse possession was pending. The answer to that question is yes. The record before this Court establishes that N47 properly alleged and put an expert affidavit before the Court that it was seeking removal of these items in order to allow it to complete its work, in order to improve its property by building to the property line.
Can I ask you a question? What were these items? What were the items that you were seeing? Because I couldn't tell, it wasn't really that clear from the pictures in the record.
It's specified in the order, but let me clarify, and I forgot to raise one point. To the extent that the order, the September 21st and the December 18th order permitted movement of the fence and the mechanical equipment, the appeal is moot to that because that has already been completed. So the only issue that's left is the removal of these brick protrusions. And I can give you a picture of one of them is at Exhibit F, which is, give me 1 second, which is on page 417 of the record.
Thank you.
And you can clearly see what the protrusion is. And it's now just sitting there. And in order for N47 to construct its building to its property line, which there is no dispute, that is the line that is on the deed, N47 put before the court the affidavit of a licensed professional engineer that set forth the reason why these had to be removed, how it was necessary, and that there was absolutely no reasonable alternative.
Counsel, there's no argument in the record that removal of this brick protrusion would cause some kind of structural defect?
Absolutely not. In fact, to the contrary, there is a statement, there is a conclusion by the professional engineer that there would be absolutely no structural damage whatsoever to the building because these items were not structural. And the court referred to that, Your Honor, in its decision on the September 21st, 2021 decision. And it is at pages 409 to 4010 and 414 in the record.
Did Gemsco put forth any expert opinion that says contrary to what your expert said about any damage to their building?
The only thing that Gemsco put in was the affidavit of an engineer who said it might possibly be this, but he had never even been on the site. And the engine and N47's engineer was on the site. Your Honor, I would like to very quickly address that we believe that the appeal from the September 21st, 2021 order is not properly before this court because it was not an appealable order. It was not made on motion. It was in response to a letter to the court, which the court directed us to do to resolve any disputes. In that respect, the appellant's arguments with respect to 871 are likewise not properly before this court because they were raised for the first time in those submissions.
What about Gemsco's claims about adverse possession? Is that part of our concern today?
No, because that's a separate, there's no relevance to the adverse possession to this because that's why the lower court's decision is within its discretion because it preserved the argument. It said, okay, I'm going to allow this entry. But the fact that I allowed this entry and now this enclosure may not be there or that protrusion may not be there, it's without dispute to your claim of adverse possession. And
but isn't adverse possession for that strip of land? And if you build on that land, I mean, how are they going to have a claim for adverse?
Well, right now, the entry, the only issue that's before the court is the entry. The adverse possession is still under, in fact, the motion to re-argue the summary judgment motion is before the court. The court never determined that Gemsco made a prima facie showing of adverse possession in any event. And there's a public interest that when you have title by a deed, you are presumed to own your property. There is no presumption that if somebody makes a claim of adverse possession, that all of a sudden you're precluded from doing anything on your property. Your Honor, I notice my time is up. I would just like to address the motion to supplement, if the court would permit me.
Quickly, I'll give you 30 seconds.
On the Gemsco's motion to supplement should be denied because the summary judgment order, while the court could take judicial notice of it, it's not really relevant, it's just a distraction. And with respect to the proposed orders, I believe that your honors have already addressed that issue, and we thank you for your time and we rest on our briefs.
Thank you. As promised, I'm going to give you 2 minutes.
Thank you. I think what's been overlooked here is that for a century, Rap Apple, well, and its predecessors have been narrowly interpreted by the court. That statute is in derogation of common law. The legislative mandate, which empowers the Supreme Court, is very limited. There is nothing in Appellate 881 that would give support to the kind of relief N47 says it's entitled to, where there is a strip of land that for decades has had protrusions. The issue, whether it's structural or not, that shouldn't be part of this appeal. The court found there has been a substantial enclosure for decades. Those N47's demolished building and my client's building, 16 stories, built in 1930, have been 2 to 3 feet apart for 60 or 70 years. The court found on the summary judgment motion, which, by the
But
way,
is she correct that the deed says it's their property?
the deed, there's a presumption of a written deed, but that presumption is, we made this argument in our briefs, and we cited many cases. The presumption of deed by written, title by written deed is negated where a party like Gemsco shows a building that has been standing for 6 or 7 decades with sine qua non, a structural enclosure. Okay? That negates the presumption and shifts the presumption to Gemsco.
What do you define as a structural enclosure?
Substantially, not a structural enclosure, I misspoke, Your Honor, substantial enclosure. And the court
What does that mean? In this case, what does that mean?
It doesn't mean it's an airtight container. What it means is there's enough, it's visible.
Tell me what it means.
What
is there that is a substantial enclosure?
Okay, we have a 100-foot strip, 3 feet wide, runs along the eastern wall of our building.
And runs on the western side of their property.
Exactly.
Okay.
On the northern end, there was a brick, they call it a filler wall, but it closed off that 2-foot space. Okay, there was a 6-story, there was
Closed off that space all the way down?
Well, on the 47th?
On the entire length of the property?
Well, you had the 2 buildings, which is the east and west enclosure of the space, and then the north and the south ends, which are about 3 feet wide each, were enclosed by brick since 1930.
3 feet of brick?
There's 3 feet of space. We're only claiming a 3-foot strip.
Okay.
So you're asking me what substantial enclosure. The court in the summary judgment motion found that there was a showing on the record that there was a that's 522, Appellate 522, that there was it was substantially enclosed for the prescriptive period. Now, they're objecting to the introduction of that. Look, yes, the court can take judicial notice of it. It's in the record in the court below. But it's a little bit disingenuous to say it shouldn't be formally part of the record because they mentioned that in their own brief. And they also mentioned the motion to re-argue, which has in their brief, which has absolutely no relevance to this.
Thank you.
You're welcome.
Johnson versus Cummings. You may proceed.
May it please the court, Andrew Levitt on behalf of Appellant Matthew Johnson. Your Honors, in our brief, we go into some detail about the evidence in the record that creates an issue of fact as to whether respondent had knowledge of Wade Cummings' violent propensities. But before I get into that, I would submit that this summary judgment should have been denied solely on the basis of the fact that key depositions had not yet been taken at the time the motion was made, an argument that respondent does not address in her brief. As we mentioned in our brief, there had been no...
Had you made any requests for those depositions? I mean, was it, was it out there? Had you served a demand?
I don't know, Your Honor. We had, in post-deposition discovery demands, we had asked for contact information for Trudy and for Wade.
And you got Trudy's address, but not Wade's?
I think we got Trudy's phone number, but not Wade's. That was in June 2020, in the middle of the pandemic. She lives out of state, is my understanding. I believe that the respondent had testified to that. And they made their motion in October 2020, so it was not really possible to take the depositions prior to that time. And Trudy and Wade are, well, Wade is the assailant, obviously, who we need to locate. Trudy is the daughter of respondent and was the only witness, other than the two people involved, to the altercation. Now, the issue here, the key issue, is whether Leone had knowledge. For all we know, Trudy's going to testify that Leone was always worried about Wade's violent propensities, and it was a source of constant worry to her. We don't know that because we weren't able to depose her. And under the circumstances, we just don't understand how summary judgment could have been granted. With regard to the evidence in the record, this is not a situation where there's a question of whether someone told the defendant that there was a risk of the plaintiff being violent. This is a situation where the defendant told someone else the plaintiff was violent, told Sandoval, the superintendent from the building across the street, that the same guy had gotten through the same supposedly locked doors in the same premises and committed a violent act. That in and of itself is sufficient to defeat summary judgment. And in addition, we do have the affidavits from Johnson and from Sandoval stating that Wade Cummings was known throughout the neighborhood to be a violent man.
What about, didn't you also make a demand for the record or the book that the defendant said she maintained to keep records of when she had to fix the locks or fix the doors or do any kind of work on the premises?
Yes, Your Honor, I was going to get to that, but she had testified at her deposition on, I think it was September 16th, 2019, that she had this notebook that contained those records. The next day, we submitted post-discovery demands asking for, among other things, those records. We didn't get a response until 9 months later in June of 2020, in which she said she had no such records.
Is there an allegation here that he got in because the door was broken?
Your Honor, there was an allegation that the premises was not properly secured. As Your Honor might recall, in the earlier incident in July of 2014.
What I read was that everybody who was a tenant in this building had a key, and that if there was a visitor, the tenant had to come down and open the door.
Well, right, but it appears based on the fact...
So my question was there evidence that on the day in question, the front door was locked such that he gained entrance through that front door lock? Because that would be the only relevance of that book.
No, Your Honor.
If there's an allegation that the front door was locked, was not functioning that day.
Two responses to that, Your Honor. Number one is that the book is also relevant because it could corroborate, it could contain evidence of the repairs she had Sandoval perform after Wade Cummings had beaten down the door to the second floor apartment. But in terms of the locks, the issue is that there was testimony that the door was always kept locked, yet somehow Wade Cummings was able to twice bypass these two locked doors. And that's an issue that we were never able to explore, Your Honor. Thank you.
Okay.
May it please the court, Christy Kenzig, on behalf of defendant respondent Leone Cummings. Your Honor, the record is clear that Leone neither knew nor should have known of any violent propensities that Wade exhibited toward other people. She clearly testified.
Well, he did live with her, right? So if he is a violent person and he lives with her, she would know that.
Right, she would know that. She testified she never saw him argue with the plaintiff. She never saw him argue with anybody else. She never saw him be violent toward anybody else.
The handyman, the neighbor across the street, Sandoval, who said he did handyman work, didn't he testify that in July 2014, approximately 6 months before this accident, he went over to fix a broken door, and that at that time, or when he finished, Wade assaulted him, and he ended up in the hospital with injuries to be treated as a result of Wade's violent nature?
So he had an affidavit where he said that he went there to fix a door. He also said that after this incident where plaintiff was pushed down the stairs, he was punched by Wade, but that postdated plaintiff's accident. So the only even...
So the incident that your adversary referred to about Wade allegedly breaking down the second a second floor apartment door happened after this incident?
No, 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 that was in July. Sandoval being punched by Wade, that was after the plaintiff.
But what, didn't Sandoval fix that door after the alleged incident with Wade?
According to his affidavit, he says, yes, he fixed the door. Now, even if we fully credit plaintiff's testimony in that regard, saying that Wade broke down this door, breaking down that door does not make it foreseeable that he's going to physically assault another person.
Well, isn't it at least an issue of fact? I mean, the court didn't allow plaintiff to have a deposition of Trudy, even though they had been some information to help locate her. Shouldn't the court have at least waited for the discovery to finish before it made a determination?
No, to show that summary judgment would be premature, you need more than speculation, which is all plaintiff has here. There's no evidence that...
This is not, wait, what speculation? The victim here says, my girlfriend is standing at the top of the stairs screaming while I'm fighting with her brother, and he throws me down a flight of stairs.
The speculation...
What's speculative about that?
The speculation would be that Leone had any knowledge of any similar type of behavior when there is no criminal record predating this incident. Leone testified she wasn't aware of any of it. And there's nothing here to show that either the notebook or Trudy's testimony would show any prior physical violent acts.
What about your client's testimony that she didn't recall exactly what the arrest had to do? The plaintiff says that after this incident, the defendant was arrested, and Leone says, well, yeah, maybe he's arrested. I don't really know why, except it happened like 2 days later. So isn't there some credibility issues here?
I don't think so. She wasn't very well versed in what was happening.
This was her son.
She has 12 children.
12 children?
She has 12 children.
But this was one of them?
This is one of them, yes. But right, she's elderly, she had 12 children. If you read her testimony, even when she's just trying to list them in order of dates of birth, she had to go back a couple times and accidentally got them out of order. So I don't think it's a credibility issue that she maybe wasn't sure about whether or not he was arrested afterwards. He wasn't even on premise by the time that she came upstairs after hearing the commotion. Based on that, my time is up. If there are no other questions, I will rely on my brief.
Thank you.
Thank you.
Very briefly, Your Honor. On the foreseeability question, the respondent has cited no case law saying that, to support their position that breaking down the door is different. And I would point the court to the Wayburn case we cite in our brief. If you look at page 304 of that decision, the court held there was an issue of fact as to foreseeability after the plaintiff was violently assaulted based on a series of non-violent crimes that had happened at that premises. And they said that under the circumstances that created an issue of fact, and we think the same is true here. And with regard to the speculative nature of Trudy's testimony, that's a little circular, Your Honor. We have a key witness who is not allowed to testify, and we're told that it's speculative because we don't know what she's going to say, but we don't know what she's going to say because summary judgment was prematurely granted. So for those reasons and for everything we've said in our
Well, it's
briefs.
not that she's not allowed to testify, it's that she wasn't deposed.
Testified at deposition, yes, Your Honor, that's what I meant.
Okay. Thank you. And last but not least, Rawlins versus Teachers Retirement System. You may proceed.
Good afternoon, Your Honors. May it please the Court. Chet Lukaszewski for Petitioner Rawlings. Your Honors, the Court of Appeals made clear in Walsh, very clear, I think, there's no prohibition on an intentional act being an accident. They specifically said, we need not consider and do not decide whether or under what circumstances injuries caused by intentional act of a third party are accidental. To me, that leaves the door open for certain circumstances
Well,
be found to be accidental. And this
Counsel,
court in
let me ask a question. Who is tasked, if not the medical board, with determining if someone is disabled as a result of the in-line of duty injury?
Your Honor, in most retirement systems in the city and state, the medical board will make a disability determination and then a recommendation as to the causation of disability. And there's an administrative body who will then decide the incident accident criteria, which to me is a legal judgment. It makes more sense. I've made the argument in TRS cases previously that I don't think the medical board should be the one deciding incident accident. They went to med school. There's attorneys who went to law school. Let that decision be made by the administrative board. But in the TRS, what the medical board says with regard to disability, causation, and accident versus incident goes. So we are left with the medical board's decision across the board.
So then what is it that you want us to do at this point if the medical board has made the determination that she wasn't permanently disabled or with the PTSD?
No, Your Honor, I'm sorry. You might be confusing the case. She is permanently disabled. She is permanently disabled from the act of her former coworker. The question now becomes, is the act, which we say is the singular event, is that an accident for disability pension purposes? Does that fit the legal accidental criteria? And our position is, even though there was maybe a building of this, she had no idea. You can't fault somebody for not knowing they're being affected. Prior to that day, when she realized, oh my goodness, this is not just a disgruntled employee. This is not someone who we've gotten out of the school. This person is stalking me. This is a stalker. He's right through those doors. He's saying, I have his belt in his wallet. To her, that went to him having sexual delusions. She never went back to work. There's a point in time. There's an event. It's out of the ordinary. It's unusual. That's what the case law says. This isn't an ongoing campaign of police officers treating somebody harshly because they were part of an investigation. This isn't an ongoing campaign where someone didn't want to be at 9/11, so her coworkers shunned her. This isn't...
Counsel, isn't it part of her job to deal with this employee?
Your Honor, if you look at...
She's the principal of a school.
He was no longer an employee because of the behavior. He was not under her direct supervision. And again, there's...
Right, but she's responsible for that building.
Absolutely, Your Honor. But there's things in all of our jobs and all of our lives we can prepare ourselves for, whether it be disgruntled students, disgruntled parents, angry companies that we're working with. Even nowadays, there's active shooter drills. Here, this is the out of the ordinary, unexpected part. This is where it became personalized. When she heard this person who she had tried to get out of the school's life, in every one of her emails, she says, I'm worried about the school community. I'm worried about the kids. I'm worried about the faculty. Only after that event...
At no point did this man assert any kind of verbal threat?
Not to her directly.
Or to the school. I mean...
That's the point, Your Honor. Up until that day, it seemed that he just wanted his job back. He just wanted to clean out his locker. That she was fine with. She didn't need psychological care. She didn't lose any sleep over. She sent the requisite emails. She said, he's an annoyance. We're getting a little nervous. He's acting strange. Can you get him out of here? I'm worried about my building. I'm worried about my staff. That day, the light went on in her head. He's asking for me. He's screaming. He's yelling. And
She's the principal. Who else is he going to ask for?
But she wanted his belt and his wallet back on that day. That's what put her over the edge, Your Honor. All the other events didn't.
You're out of time. You'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, Janet Zalian for TRS.
Am I missing something? Was there something else other than someone who was not accepting that he had lost his job? I mean, were there any other threats other than him coming asking for things he continued to claim he left behind?
No, that is what he was doing.
Counsel used
He is the principal. The Court of Appeals definition of accident, and that's the only issue here, is whether the medical board rationally determined that there was no accident here. And the Court of Appeals definition is very clear and what they call a common sense definition. It's that It's a fortuitous mischance. It's sudden and unexpected, or even if it's not precisely predictable, it's not a risk of the work performed. And as the court's questioning has indicated here, the court understands that she's the principal. She's dealing with any intruder who comes in. He's not supposed to be there anymore. It's true. He's been reassigned. He's been coming back, trying to get his possessions, trying to find out. He erroneously believes that she can get him his job back, but she doesn't hire food service workers. But dealing with an irate person, whether it's a parent, whether it's a student, anybody who comes to the school where her own description of her job on her disability application, where she says, this is my job, is to ensure the safety of the school. She says that she's gotten threats in the past. Her subjective response to whatever he said that day, and it was unusual for him to say, she's got my wallet in my belt. What does that mean?
Right.
But that does not transform his behavior into an accident.
Counsel, your adversary used the word stalking, which, to be quite frank, I was taken aback by because I didn't read. Were there any allegations of stalking? Was there an investigation, a referral to the police department, something?
No, he was ultimately arrested for trespassing, and there were communications among DOE. At one point, actually, the police came and escorted him out of the building when he was being disruptive. She's saying that I felt stalked this time. That's what she's saying. She thinks that she feels as if she's being stalked.
And I believe at one point in the record, she says that after he was removed from the building, she noticed that he was standing next to her car outside. So I could see that as being disturbing, and that would concern me in that scenario, but is that enough to constitute an accident?
No. She is the principal. It is, apart from the fact that this court has repeatedly held, including in the recent Amar case, that kind of purposeful conduct is not an accident. But apart from that, it is certainly a risk of her job as the principal for her to have to deal. She's the person, by her own account, in her own disability application, she's the person who handles ensuring the security of the building. She did it before when he came to the school in February and March, and somehow in April she's now saying this is an accident, and that is not true, Your Honors.
Thank you.
Thank you, Your Honors.
Hey, Counsel, you have a minute on rebuttal.
Your Honors, the stalking was the term my client has used throughout. The individual was later arrested. Part of the arrest was the trespassing offense of that day and of a second return to the school. She was not there. She has never gone back to the school. I'm not, if Your Honors aren't going to, I don't want to say appreciate the significance, but this is a strong woman who has admittedly dealt with many a circumstance in her career. The respondents' doctors, their psychiatrists recognized the impactfulness of this event. Their doctors found her disabled by it. It's not an ordinary occurrence. It's not something a school principal prepares for, to have the focus of an individual of this alarming nature upon them. They can prepare for a fire drill. They can prepare for a lockdown. They can prepare for angry students and faculty. This was out of the ordinary and unique, and it has absolutely changed her life. She's been found disabled. She's out on 1/3 when it can be 2/3. There's no prohibition against that by the Court of Appeals. And in the Carr case, it was so out of the ordinary when the boxing instructor told the male instructor, hit that woman like she's never been hit. And this court found that to be an accidental event. This is unique and should fit that criteria also.
Thank you.
Thank you. Thank you.
Gotcha. What happened? Did you do it?
LT?
No, you can't. Unfortunately, there's cameras.
Sorry about that.
Nobody believes me on license plates.